Right. Good to go.
Stand by. It's winding. Anytime, Madam Chair.
Thank you. Okay, good morning, everybody. This is the hearing board of the South Coast Air Quality Management District. Today is December 28th, 2023, our last meeting for the last hearing for the year. We do have to take care of something in-house first. We have Dr. Abraham, who will be attending remotely, and this is under legal requirement AB 2449 that the board needs to vote that we are accepting that. So in reference to that, board members, if I can have a motion.
So I take it what you're saying is he has to
Yes.
appear that way because of a health emergency?
Dr. Abraham, would you like to repeat your disclosure?
Yes, correct. Yeah, I'm happy to share. Yes, I tested positive for COVID and I'm currently sick with COVID.
Thank you. Okay.
I so move we accept that he meets the exception for the remote appearance as described by the chair.
I'll second it.
Thank you. Any discussion on that motion? Okay, and we will start with Mr. Ali. How do you vote? Let's start with Mr. Pearman. How do you vote, Mr. Pearman?
Aye.
Mr. Balagopalan?
Aye.
And can we get Mackay on there?
He's using his phone to speak, so he just needs to star 6 to unmute. Camera for video, but phone for audio. Board member, you've been unmuted. You just need to unmute your own phone.
Using *6 to unmute the phone.
Paul, has he
Yes.
unmuted?
I've clicked the ask to unmute several times.
Okay. Madam Chair, he is permitted to speak. He
Yes.
is using a phone and it appears that he is still muted. So I don't know. There's no way for us to unmute
no.
him.
No, but with the three of us, we do have a
I'll
quorum.
send him a text maybe.
Yeah,
Because we need him at least not just for this, but for other things.
Right.
to be available. So let's
Might have stepped away.
possible. Sorry for the delay.
I'll send him a text as well.
Yes. And so then we're, this one that was used as she showed, so 12, should be yes. So it's exactly. So it works. Yeah.
Mr. Ali, we've recognized you. You just need to unmute your phone. *6. that correct, Al?
That is correct. We recognize that his hand is raised, but he's not unmuted. And we've tried several times to unmute him or move him. Okay, now he's unmuted. Now he muted himself again.
Right, can you
Yeah,
guys,
he
can you
keeps
let me
muting
into
himself.
can you let me into the meeting? I'm logged on here.
You are.
Right, so
You are in the meeting.
can you show my
Yes,
picture?
but we need you audio by phone, Mr. Ali, and visual will
Okay,
be
I'm
via
logged
the
in
internet.
visually. Can you let me in? I can't, I'm not,
You have
able-
to accept.
well, I never received anything to accept.
Well, you have to accept as a panelist, and then I think you'll show up as a panelist.
I never received a
Well, you're
request.
showing up on the screen as a panelist.
Yeah, I think you're already a panelist. Makai, is your camera on as well?
No.
And
No,
are you using your phone, Mr. Ali, as
no,
audio?
no, I'm not.
Yeah, I think that's the issue, Al, is because you know, he
Lost.
we just disappeared again. Because I just heard his audio through as a panelist.
Correct. We did have it, but he's gone now.
Right.
You cannot hear us, Mr. Ali?
And he dropped off as a attendee too. So it might be something with his PC. There he is again.
He's back in?
Yep.
Yes.
Mr. Ali, can you hear us? He can't respond.
Oh, yeah.
I just clicked him to
He
talk.
just went over to, there he is.
There he is. Okay. Okay.
Mr.
All right, we
Ali,
can see
I
and hear
see his
Makai.
face.
Yep.
Yes.
we don't.
If he talks, you'll see his face, Madam Chair.
Okay,
Yeah,
Mr. Ali, if you could speak, please.
I'm
Give us
here.
a-
Why don't we go ahead and get started? Let's rock and roll.
there we go. There we go. All right, Mr. Ali, we are in the midst of taking the vote to allow and vote for or against Dr. Abraham utilizing the emergency part of the new Brown Act 2449 due to the fact that he's got COVID. There is a motion on the floor that was seconded to accept Dr. Abraham, and we are just waiting for your vote, sir.
Aye.
Okay, I also vote aye. It's unanimous, and we do accept Dr. Abraham utilizing the emergency aspect of AB 2449. Thank you for that, sir. Okay, we can start again in reference to the cases that we have before us today. On the consent calendar, we only have one, and it is Lakos Dye and Finishing, Inc., case number 6237-2. This is for a modification of an order of abatement. We therefore have exhibits. And exhibit number 1 is the stipulation regarding putting this case on the consent calendar.
Madam Chair?
Yes,
I'm sorry, but this is an existing case, so we are at exhibit number 5 for the petitioner.
however, this is -2.
Right, this
Okay.
is an existing,
Okay,
and we're modifying an order for abatement, so we'll be at exhibit number 5 for the petitioner, A
Alright.
for the
yeah, I
respondent.
have A. All right,
And if there are any hearing board issues, it would be HB2.
correct. Thank you. All right, so exhibit number 5 for the stipulation. That would be 6 for the Declaration of Gloria Anna Beer or Anna Beer. And number 7 for the proposed modification to the stipulated order for abatement. And that also includes, there are 2 exhibits within that proposed findings and decision document. And it'll stay as the same number. And then we have also the declaration from Mr. Lee, and that'll be marked as A as an apple. Okay, and we want to start deliberation on that.
Would that be number 8 instead of A from Mr. Daniel Lee?
No, A is an apple,
A is an apple.
because it's coming from the
Oh, petitioner.
respondent.
Yes, okay, thank you.
Okay. Okay, did we want to begin with that? Just to give a little bit of a background, Mr. Lakos owns Dye and Finishing, and this is a case where it had to do with reclaim and the credits for reclaim and the cost of the credits for reclaim for Mr. Lee to stay, to try to stay in business. And he was here before us. I don't have the date. I did have it previously, that he came before this hearing board and gave us the background to his company and his situation. He has been working with Deputy District Council, Ms. Manwaring, and this is the result of that agreement.
Yes, I agree. And I mean, he's going to inactivate his operation. So good cause has been shown for the modified order, I believe.
Any other discussion?
Yeah, it's going to say, it was August 10th, we heard the stipulated order abatement, and there was several conditions on the order, and it appears he has not complied with any of the conditions of the order, and he got subsequently additional NOVs. But I think the condition number 6 was for the RTC, so the permit get issued, and I think he indicated that he's not able to do that, so he's going to shut down his business.
Correct.
Uh,
Unfortunately,
Unfortunately, yeah.
right. Not something we'd like to see. So with that,
I was going to add that, I know, I'm in deliberation, right? Yeah. That part of the condition of the order was for the, to cancel all the open application. And I think that was the problem I had before too, and I opposed the stipulated order abatement was that the permitting action should be separate from the hearing board. And the district had additional, I think they were given until December 7th to put by December 1 in condition number 6 to get the additional RTC of 7,580. At which point they didn't. They could have. In my opinion, they should have denied the permits the pending application. Is and now we're asking them to submit a request to cancel. So that's the only issue I have, basically. Otherwise, it's unfortunate. Like it indicated, it's unfortunate that he's shutting down his business, and a lot of employees will be laid off. Part of the, I think I sent an email asking, he's allowed to remove it off site. Maybe somebody else will buy it, or I don't know. And then hopefully there'll be another business that might take over the equipment and operate it, because I think if they start anew, they won't be in reclaim. That issue won't be there. But unfortunately, with the condition that is put, he has to either remove all the equipment from the facility or permanently render inoperable equipment at that location. So he cannot operate at that location. I think whoever starts, I think the bigger issue would be water issues and all that. I don't want to go down that road, but I think that's an option available. And we're not consulting for him or anything, but hopefully somebody will take over, and maybe that the business and the employees may be hired back if somebody takes over and runs the operation.
he did notify his employees that as of December 18th, that the last day of their employment would be December 31st. And he has begun the process of closing the business, and he will stop operating on February 1, 2024. So it's like we have all felt it's not something we like to see. However, it is governed by the rules and the regulations of the South Coast AQMD, which is inclusive of reclaim. And while reclaim itself is going to be sunsetting, we don't have that date and therefore could not give him an actual date when, that he could target. So with that,
From,
any,
Here,
no,
Dr.
no,
Abraham.
no, because they're not here for that. They're here for,
no, I meant Dr. Abraham or Mr. Ali.
oh, yes. Mr. Ali or Dr. Abraham, do either of you have any comment in regards to this case?
No additional comments at this time.
Thank you.
Now, just,
Mr. Ali?
yeah, I was just curious. So based upon the discussion, so we're not hearing the case today? Did he withdraw?
It's on consent. It's on the consent calendar. And so what we're doing is our normal process of going through the exhibits and deliberating, and we need to vote on it. So that's what we're doing at this point.
Right, so the
Parties are
discussion,
not.
yeah, the discussion regarding him, Mr. Lakos, regarding the gentleman going out of business, then why would he not simply withdraw his case?
It's a stipulated order abatement, so I think it's a modification to, on the stipulated order abatement. So to basically,
It would have come from the district, since the district is the one who petitioned for the order of abatement.
Yeah.
So that's the process we went through. She did give him the conditions that he would have to have met, but he was not able to, so he has decided to close that business. Mr. Pearman,
Ready to make a motion whenever you're ready, Madam Chair.
ready to,
So in the matter of case number 6237-2, South Coast Air Quality Management District versus Lakos Dye and Finishing, Inc., Facility ID 141295. Matter involves District Rules 203, 2004, 2005, and 2006. I move that we have a good cause to grant the modification to stipulated order for abatement. This involves the facility at 3131 East Harcourt Street in Rancho Dominguez, California, and the various items of equipment, et cetera, listed in the stipulated modified order, which in essence, the order as modified provides for the cancellation of open applications and an inactivation of certain equipment listed therein.
do I hear a second?
Second.
Okay, any discussion on the motion?
yeah, I was just going to vote no, as I did in the previous stipulated order abatement. Again, because of the procedure wise, the first condition of the revised order is to cancel, and I think the appropriate action should be for the permitting group to deny those applications, because they extended it several times, and they were waiting for the hearing board to take action, and I always feel that should be a separate, pathway.
Well,
So anyway, so I'm going to vote no on that
Okay,
one.
kind of.
Also for the reasons I stated before in the.
Thank you for that, Mr. Belakapon, but unfortunately, now it's kind of a moot point because he is going out of business, and he even told us at that hearing, it was a good possibility he was gonna go out of business, unfortunately, which we were all trying to avoid, including district council, so, it is what it is, at this point, unfortunately. So, any other discussion from Mr. Abraham or Mr. Ali? Dr. Abraham, I'm sorry, or Mr. Ali?
No additional comments.
Thank you. Okay. All right, so we will vote. Mr. Ali, how do you vote?
Aye.
Dr. Abraham?
Aye.
Mr. Pearman?
Aye.
Mr. Balagopalan?
No.
And I also vote aye, 4-1. Okay. So that matter is closed, and we can go on to Shadow Wolf, who is here for an interim variance, case number 6244-2. And it's at facility 196103. I don't know whether you're familiar with the process when we have an interim request for an interim variance. It goes in two parts. The first part will be that we need to find good cause. And if we do find good cause, then we will go on to the second part, which is the 6 findings, to be able to grant the variance. So with that, who do we have here on behalf of Shadow Wolf? Please state your name, spell your name, give us your title, and how long you've had that title.
Adam Onstead, CFO Shadow Wolf. Had that title since August this year.
Okay. And what was your title again, sir? I'm sorry, I didn't hear that.
CFO,
CFO,
Yep.
okay. And spell your name, please?
my apologies. OHNSTAD. First name Adam, ADAM.
Okay. All right, and on behalf of the district?
One more.
Oh, I'm sorry.
No problem. And this will be easy. Same last name, OHNSTAD. My name's Zach Onstead. I am the cogen supervisor for Shadow Wolf Energy. Been there for, in this position, 6 months to a year.
Okay, great. Thank you. All right, for the district?
Good morning. Stacy Pruitt for the executive officer.
All right then. And are you going to have witnesses that you are going to ask to give information and be questioned?
The district does not anticipate having any questions. However, I do have someone from engineering and the Office of Compliance and Enforcement, should there be any questions for them. My first potential witness would be Monica Fernandez Neild. She's the supervising air quality engineer. And the second is Adam Tavasolian, Tavasolian, and he is an inspector.
Okay, I was actually asking the petitioner, but that's
Oh,
okay.
I'm sorry. I thought
That's
you were
okay.
speaking to
No.
me.
I always go to the petitioner first.
No, I thought
That's
they were
okay.
finished.
Okay, so who will you have as your witness?
No witnesses, ma'am.
Okay, so you're not going to be asking anybody within your party questions so that we can understand where you're coming from in reference to
Besides us two.
requesting? Yes, you're not besides you two. Are either one of you or you two going to be providing information?
We would both be happy to
Okay,
speak.
all right, so then you're going to be your witnesses
Okay.
for today.
Okay.
And you will have any witnesses again, Ms. Pruitt?
I will not be calling any witnesses, Your Honor, but I have Monica Fernandez Neild
Okay.
here and Adam Tavasolian, should there be any questions for
Thank
them.
you. Okay, so all those who are going to be providing testimony, if you can please stand and raise your right hand. Do you swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Okay, so with that, we can start with your opening statement. And if you can please refer to the good cause part of it. Do you both have a copy of what good cause is as well as what the 6 findings are? Do you have that document? They don't. Okay. All right, we're going to provide that for you. Okay. Do you need about 5 minutes to go over that?
That would be great, please.
Okay. All right, we're off the record for 5 minutes. Okay. We do have a document before us in reference to this case that we would normally be marking as number 1. However, there's a question in reference to, and I'm going to defer to the district's council regarding the fact that they were told that they needed an AOC when it's a possibility that they do not. And there has been no credit set up because of the fact that they don't need an AOC. Are you aware of that, Ms. Pruitt?
Yes, your, excuse me, Madam Chair, they do not need the AOC. It is not. They do not need the AOC because it is not offshore.
Okay, thank you for that clarification. But I'm going to leave this in our documents. So I will still mark it as number 1. Okay, and that's the only exhibit I believe that we have, correct, Madam?
At this time, other than the revised petition, we have no other exhibits from the petitioner.
Thank you so much. Nor from the district.
We do have conditions from the district.
Other than the conditions?
Other than the conditions, no
Okay.
other exhibits.
All right, and then we will be marking those conditions as A as an apple.
Did I get conditions?
It was emailed.
They were emailed?
I'll take a copy also. Thank you.
This will be A.
A.
And then I want to make sure, Madam Chair, the document you referred to, that even though they don't need the AOC that you're talking about, is the email from
Mr. Dirks.
Mr. Dirks of December 21st, which is what we're referring to.
Correct.
Okay.
With the graph
Thank you.
in back of it. Okay. I think we're all set as far as the exhibits. And so, sir, you can go ahead and you can start with your opening statement, which will be in reference to good cause only. And if you can give us that information, sir.
Yeah. Good morning and thank you. So Shadow Wolf, we believe that we have good cause in this matter as we've acted diligently, timely, to the best of our abilities to bring forth the cause as it's become aware. The timeline on this, we come out of compliance, Rule 1134 as of December 31st or January 1st, as we will not satisfy the source RATA and verified compliance with the NOx emissions and catalyst constraints. The broader issue that has led to the delays here was an overriding ownership dispute of the entity. In March of 2023, there was a shareholder-derived dispute, and it included a cease and desist order from one of the managing partners against the other managing partner. This order, which was entered in state court in Nevada, prevented either managing partner from acting in a unilateral manner on essentially anything and created a full gridlock within the entity. It became aware also in March that the NOx catalyst vendor indicated delays in what's the word? Manufacturing supply chain. That was leading to a nearly 9-month lead time, or expected 9-month lead time on this new catalyst to be acquired. And when the purchase order was put forth to the managers, we could not obtain or Zach, could not obtain consent and get that purchase order to move forward. Subsequently, on August 3rd, there was a agreement made between the partners, partner groups to settle the situation. The settlement was completed on August 16th, 17th, somewhere in that window. And when it was clear that the arrangement was in its final stages and going to come to fruition, the controlling partner took action, issued the PO on August 14th. Subsequently, a number of events took place, as you can imagine, in a situation where you've got partners that are in full disagreement. Not to mention a management overchange, because the management team was part of the ousted partner group. So come, I guess the last variance hearing that Zach attended for the missed RADA test on Unit 2, which was being removed. It was a non-functional unit at the time to perform the RADA. We got notice on November 30th in conversations with staff at AQMD that this variance needs to be dealt with imminently. And we acted in quick fashion, as fast as we could, to get the petition put in place. The interim variance is because the rule takes effect on the 1st. And I believe the public hearing actual variance is scheduled shortly thereafter.
On the, is it the 18th, Madam Clerk?
Of January.
Right, of
Correct.
2024.
Yes.
Okay. Thank you. Okay, Ms. Pruitt?
Yes, good morning. At the close of our conversations with petitioner, the district was not opposed to the petition, nor did we think that they would not be able to make good cause. However, since that time, there has been another document submitted. So the district would like to reserve their position until the submission of the evidence.
When you say another document, are you talking besides the graph? Or are you talking about the graph?
Well, I'm talking about the graph.
Okay, all right. All right. Okay,
Well, could I ask a question, just because on good cause, how does the graph relate to that issue?
Well,
Because that's just an excess emissions graph. if I
right.
recall correctly,
So that would go to the merits of the case.
Not applying for AOC, so that's moot.
It seems
I
it's
don't think we
moot.
need to.
Yeah.
Because we revised the petition, we did not request AOC, so.
So we don't even need the graph.
We don't need to graph.
So it's a moot point.
And it was mostly because, excuse me, they revised the petition, I misspoke. And with the petition being revised, I wanted to hear what any new testimony
I
might
see,
be.
okay,
So that's why I'm reserving,
okay,
Fair enough.
not the graph.
not the graph. Thank you.
Thank you for that.
Mhm.
Any other question, Mr. Pierman? Okay. All right, with that, you can call your first witness. Sir? Yes.
If,
Just before, Mr. Adam, you're not able to see, is that what it is, the situation?
That is correct.
I'm
Okay,
so sorry.
All right.
I have retinitis pigmentosa, 100% total.
Oh, okay.
I'm so sorry to hear that. Okay, my mistake.
It's okay.
I'm assuming you can see me and I just thought, well, maybe the lights bother him.
So I had sight as a kid, so my eye contact, I speak to sounds, and I always get that from people. Adam, I'm sure you can see because you look at me, and it's we got to do what we got to do, right?
Yes.
and
So-
I'm sorry to, I believe that he would like to testify in the narrative is what would be the legal term that he
Yes, in
plans
the
on
narrative,
doing.
yes.
Exactly, because
Okay.
you won't be asking yourself questions and you would just be testifying
Mhm.
in a narrative format rather than being asked questions unless there are follow-up questions that I or the board has for you.
That's correct.
That would be great.
And also, your opening statement would be inclusive, as I mentioned before, good cause. However, since you gave us a background already, then your first comments could be, either in addition to those comments of the opening statement, or if you want to go straight to your witness and start questioning your witness, which
Okay.
is your brother, I'm assuming.
That is correct. So I would like to ask Zach to speak.
Okay, well, in the narrative, or do you want to ask him questions?
In the narrative.
Okay. Is that okay with you, Ms. Pruitt?
Yes, as long as it.
If
I
it
would just-
doesn't cover whatever you need, you can always ask him questions.
Right, I just wanted to make sure that it's very clear in terms of, what's the word I'm looking for? It's in order of the document that you would be discussing. That would make it easier for me to address you.
In reference to the good cause document?
In reference to the good cause document. I believe you have a copy of it.
Great.
Thank you.
Would you like that we go down line by line?
If that is easiest for you.
Okay. Unless you want to ask me the questions.
Okay, you need to turn on your mic.
Sorry about that.
Okay, we're talking about just good cause.
Just
Okay.
good cause sheet. Yes, ma'am. Why is a variance needed? What rules or permit conditions are involved? And I could answer, well, I guess it was kind of narrative because I'm answering. But the rules involved are 203 Bravo, 2004 Foxtrot 1, 302 Charlie 1, and 1134 D3. How's that your company is or will be in violation for those rules? Yes, so as of January 1st, we will be out of compliance of that 1134 rule due to the NOx emissions lowering, the NH3 slip lowering, and the CO emissions all lowering to a standard, and our catalyst is not able to, current catalyst is not able to meet those standards. Timeline of events for the violation. Let's see. So it starts back in March of this year, March 2023. Us as an entity, Shadow Wolf Energy contacted multiple catalyst vendors. Within that same month, we started purchase order discussions with a company that we chose, which was Umicore Catalyst. Due to ownership conflicts, the PO of the catalyst purchase of Umicore was not able to be issued there in March, and the ownership conflict went to court in March for that disagreement. The settlement agreement was reached August 3rd of this year, 2023, and the PO, once that was settled, the PO for Umicore and the new catalysts were able to be issued August the 14th of 2023. And like I stated, yes, the settlement agreement was executed on August. If I said October on any of these, I apologize. These are August dates. August 17th, the settlement agreement was executed, which is 3 days after we issued that Umicore PO. In November of 2023, Shadow Wolf was notified by AQMD staff that was working on the permit of modifications that the unit would need to also meet the reduced ammonia slip, which is that backed rule. This required a change to the catalyst to be installed. The catalyst that will deliver and a reduced ammonia slip was ordered in, so yes, we had prior to that in August, put in the PO, ordered the catalyst, but when that back roll came, we had to go back to them and have them make the changes, and it was a whole new catalyst material and everything. And that new order was in November of this year, 2023, with an expected delivery date of March 2024. The delivery of the catalyst is not expected until March, and the rule 1134 requires that the turbine meets that lower NOx limit of 2 ppm and before the end of 2023, with the permits and testing to show as well. The current catalyst in the units cannot meet that lower limit as stated. I believe that concludes the timeline. Going on the next, this will be for public notice. Is this reasonable to ask for the hearing without public notice? Could your company have avoided the circumstances that made a variance necessary? And some of these could be questions to you, so I will ask you that as a question. Adam.
So I believe the timeline fits to have an interim without public notice, simply for the fact that the rule goes into effect here in 3 days, and our official variance hearing is on January 18th after that deadline. The granting of this that you're considering is, I don't know how to say it. We've modified the run profile of this unit to where there is no voluntary running of these turbines to reduce power to the grid. They are called upon, they're under a resource adequacy contract, and they'll be called upon only in time of need by the grid. And that's when we will fire up. And it really, in terms of what we've seen in the electricity market, it is not the most desirable unit to fire up. It really requires peak demand. The winter storms last year, the heat waves. Are there events that could happen? Yes. And it's the expediency of ensuring that should something catastrophic happen between January 1st and January 18th, albeit unlikely, that the rules are in place, or the variance is in place for us to fire up at the request of the state.
Does that conclude your comments?
Mm,
On that line item, yes.
There's a few more for
Go
a
ahead.
good cause still,
Okay.
so continue on. Yeah. Was a variance petition filed promptly? When was it first known the variance would likely be needed? When was a petition filed? I could be able to answer this for you. Maybe not. Let's see. I'd like to read it. So we were aware as a company that the variance would be needed. However, it wasn't until a conversation we had with Emily Chow and Monica Fernandez-Neild, which took place on Thursday, November 30th, that we were needing the interim variance. And so as soon as we knew that interim was needed and necessary, we did put it in place and filed it. What? That will conclude the statement for good cause, ma'am.
Okay, thank you. Ms. Pruitt, you have questions for this witness or witnesses?
Yes. Can you explain why it was beyond your control to comply with the rule and the permit conditions prior to March or after March?
Yeah, so the operating agreement between the managers had a dual manager unanimous provision and prevented them from incurring any cost in excess of $50,000 without unanimous consent between the two partners. And the conflict, although filed with the courts in March of 23, really started, months before that, where disagreements were taking place. And it was challenging on many fronts of the operation, not just this, obviously.
Okay, since you said there were difficulties prior to March 2023, could you have anticipated that you would be in the position you were in March 2023 and would be potentially out of compliance?
No.
Okay. And when did you first realize that you could be out of compliance?
I guess that would have been August when the PO was issued and the conversations were finalized with the vendor to show the lead time.
Thank you. Did you take any actions to achieve compliance between March and August?
Yes, conversations were continued with the vendor and constant requests, but were made to the managing members. Meetings were called, but no votes were able to be obtained
Why is that?
or lack of unanimous consent and disagreement between the parties.
Okay.
And we were under a strict, or they were under a strict order to comply with the court that was monitoring the disagreement.
And in the event that this variance were not granted, what impact would that have to your business?
So it would prevent the units from being able to run. It would impact our resource adequacy. We would be violation of that.
Okay. And do you know roughly what this would be in terms of a cost to your facility?
Approximately $2 million.
Is there any other actions you could take instead in lieu of obtaining a variance that would be satisfactory to continuing to operate your facility?
No.
No further questions.
Thank you, Ms. Pruitt. I have a few. I want to make sure that I understand this timeline. Number one, you did not submit a timeline on a separate document. Is that correct?
Go ahead. I am unsure.
I believe just the petition document had the
Okay,
timelines.
all right. Because that's normally what we do ask for in reference to an interim request for an interim variance that gives us a little bit clearer picture of what's going on and when things occurred. But in reference to that, you stated that it was August of 2023 that you needed a variance. Is that correct?
The question was, when should we have known that we needed a variance or would have been out of compliance? So there wasn't a knowledge of the variance, but that's when I guess we should have known we would not have been compliant come 12/31 because the catalyst.
Okay,
would
but
not be
there's
there.
no one who, you didn't have an environmental manager, let's say, that you would be out of compliance with the AQMD? Or anybody within your body?
He was also terminated
Mm.
through the,
Okay.
yeah.
So coming back to November 30th, you were advised by the staff of the AQMD?
Correct.
Okay, and was that because you called them and were asking questions of what steps you needed to take, or what made you want to call?
So the staff engineer was looking into, I believe, the permitting required, and it was through the course of uh, that he determined we need to call AQMD and figure out what's going on here, and then we were notified of it.
Okay, and that was November 30th?
Yes.
Okay, good. All right. In reference to your unit running and it being deployed, you're saying last due to the fact that it is the most inefficient, or what's the reasoning that you know that you would be deployed last? It come a demand.
Just what we've seen seen based on the dispatches. You know, solar goes first, and then the stable, nuclear and the dams, and the gas-fired resources are not their go-to resources.
Okay. Do you know whether the last storm that we had last year, whether your company was requested to provide service to the grid?
During the winter storm?
Right,
Yes, ma'am.
you were, okay. So it's very possible that you would be called upon again. It's should we have a similar storm?
Yes.
Okay, and you may not know this. Do you know how much power you normally do provide into the grid?
17.5 megawatts
Good, okay. Good to know.
out of one unit, being that unit 2 is down.
Okay. Do you know what you provided last year?
In total megawatts?
Right,
I do not.
okay. Was it more than the 17.5? Did you have more than one unit going?
So yes, our capacity is 40.2 megawatts per hour. So that's 17.5 megawatts per hour,
Yes.
to the grid.
Okay. All right, those are the only questions I had. Mr. Pearman?
So in your modified permit, as Madam Chair asked you, you said in November 2023, you were notified by AQMD staff working on the permit modifications. So first, what were those permit modifications that you're referring to there?
That is when, from the permit, we were adding the changes in from the catalyst, and it got attached from, it had a backed statement in it, and that's when we started reaching out to AQMD. But it was a backed rule that was thrown into it, and more adjustments were needed then.
Okay, so the permit modification related to the fact that you had to put in the catalyst. That's what the permit modifications were?
Yes.
Okay. And so again, you talk about a reduced ammonia slip. So explain again more detail what that meant and why that would then therefore lead to a delay in meeting the requirements.
So it's all the internal components of the catalyst and the reactivity of it, and the normal that was on the permit was 20 tons, 20 ppm slip, and well, that was reduced down to 5. So yes.
Okay, so initially you had to modify the permit regard to catalyst, but then you basically had to change those modifications because of the reduced ammonia slip. So you had to like redo the catalyst, so to speak. All right.
Yes.
Now I noted in your initial petition that we acted on in case, I guess it was 6244-1, which we heard, I think, back in October, there was never any mention of this ownership dispute as a reason for any part of the request. I'm just curious about why that was omitted from that, as that would have been part of a reasonable explanation of why you wanted the interim variance in that case.
Probably just due to the fact that I felt like that was above me. I was here with my outside environmentalist and yes, it was just,
And I would like to lodge an objection that at this point, it would be assuming facts that are not in evidence in this hearing.
I have to agree with that unless we, if we're asking questions, I believe we can ask questions about the other, well, I'm not sure about that. I'm gonna defer to my,
No, I can ask the question.
yeah,
He answered best
even
he
if it's a
could.
different case number.
I don't know what to, yeah, well, it's relevant, obviously, because we're
It
trying
is
to find-
relevant.
so-
That's,
Yeah, my question is relevant. His answer is his answer. So I would overrule whatever she's objecting to.
I'm tending to lean that way, Ms. Pruitt. Only because the fact that we need to really find out what went on, and if he was given information that was, not, how can I say, not advantageous to them, their own consultant, which surprises me because that consultant has been in business for quite a long time. But I understand your objection to facts not in evidence. But if we're asking him now, because of this case, why they didn't mention that in this petition as well, I would like to know that.
But we're calling on something that's from an outside universe. It's something that was not in this particular hearing on this date. So I'm at a disadvantage. The district is at a disadvantage because I believe it was Karen Manwaring who would have the information pertinent to that case. And I do not have that information. So as far as I'm concerned, there's a lack of foundation in stating that what was or was not submitted at the last hearing.
Well, I asked him why they didn't put that in the prior petition. The petition speaks for itself. His answer was he didn't have a good reason.
Okay,
What do you
I just don't have, because I just don't have a copy of that petition, so I don't.
Well, even in
should
this
be-
petition, in this.
Okay,
current
that would be
petition.
more pertinent, I think, to the case, why in this petition, but I don't know how to examine him on what was on another
understand.
petition in another hearing that I was not privy to.
Can I continue?
Continue.
Now, just so the catalyst we're talking about, is there a catalyst to each of the turbines we're talking about, or just one catalyst?
there's separate catalysts, one in each heat recovery steam generator attached to either turbine.
Okay. And I do, again, I think we do have to address the prior case because there is a variance with respect to turbine 2 already, which I recall just says they're not operating it, and when they refire, they have to let AQMD know so they can do the rata test. So now in this one, you list both turbines, and in your conditions, the AQMD refers to turbine 2. So we do have to discuss the kind of an explanation that's overlap, so we don't issue something that makes no sense here. So why did you put both turbines in this, and how do you see that interacting with the variance that you already have for turbine number 2?
So if we assume that the variance for unit 2 concludes in June, at that moment, it's out of compliance. Right? Without the variance.
And, well, let me put it this way. Under the current modified petition, how long is the variance you're seeking? I thought it said that the catalyst would be finished well before June. Did I misread that?
Yes, the expectation is that it is received in
March.
March. Yeah.
So that answer kind of says it's still curious that you want, I don't understand how that answers the question as to how you see the first petition interacting with this one that encompasses the same turbine.
I go ahead.
I feel like you could say the same to the opposite. If we didn't put it on, it could be asked, why was it not put on? I think it's a safety thing because we were unsure, or to be safe, to make sure that they're both protected in this case.
I do note that the rules you cite are slightly different in each petition, so maybe that's a reason, but it does leave us struggling because we have to issue a ruling at some point, and it's kind of confusing. Does AQMD have any comments about that? I understand you apparently weren't aware of this first petition, it sounds like.
Well, I was aware of it, but
I was aware of it, but I do not have the specifics of it like Ms. Manwaring would, and I can't speak to the district's position or why. So again, it leaves me at a disadvantage.
Did we have this? I'm sorry, go ahead, sir.
Proposed conditions that included turbine two, so
Well, turbine 2 will not be functional until June of 2024.
However, were you the same engineer that dealt with the first case? You were not, so you had no information on that as well.
She is on vacation.
I'm sorry, I didn't ask for your identification. We didn't, go ahead.
So that is correct. She is not available. This is not the same engineer that was present at that time.
So we have a turbine that's already under a variance listed, not identified by either party that it was already under this other variance. And we're also looking at number 1, which this really should only be about if there's already another variance on number 2.
I believe
Am
that.
I incorrect on that? I'm correct on that, correct, right? There shouldn't be 2 variances on the same turbine of number 2.
Again, it depends on what the variance was for the first hearing. And that's what I'm saying. I don't have that information because there can be more than one variance, but I just don't have the adequate information because I was not here for that hearing.
Go ahead, Mr. Bog.
Oh, yeah, and and you can see our confusion, Mr. Onstead, and Zach, I'll ask you, turbine 2 is not in operation, correct?
Correct, sir.
And it will not be in operation until you do the repairs and bring it online sometime in, before June.
Yes, sir.
You're not in violation of 1134 because you're not operating the turbine, correct?
Correct.
Okay. You, however, are retrofitting both turbines to meet the low ammonia slip ppm limits.
Yes,
with
the
catalyst.
The catalyst, yes.
Okay. So, so I think that's, I think that, okay, we can address that, whether it's, because when you first came in for the variance for number 2, it was for the radar test, the ammonia test, because you couldn't do it by the end of the year. You did not at that time request a variance from 1134. And I'm questioning why. Did you think at that time you would comply with the 20 ppm limit and you would then later inform it as 5 ppm?
That is correct. We didn't know until that ammonia slip was lowered in November when that came back after that first variance.
So did you get a permit revision that showed that the limit was lowered to 5 ppm, or you got something verbal?
It was a permit revision.
Okay, okay. When specifically, do you have a date when in November, you mentioned November, do you have a specific date in November that you knew? You have November 30th, by the way, when you were told to get interim variance. I want to get a date in November when you were told, or you got the permit that showed the limit was down to 5 ppm. If you have it.
If I may assist with that, I think that it was a draft permit initially, I'm told.
Actually, we can wait
Okay.
to see if he can answer that, and then we
Okay.
can go to Mr. Fernandez later.
Yes, I'm still looking for it, and yes, they were drafts. They weren't finals. It was a draft that was sent to us. And I do not have the exact date, sir.
Okay. Prior to that, when you submitted the PO in March, will you understand, if, let's say that wasn't changed, hypothetically, that ammonia slip was not reduced, was the intent, was the expectation that you would have the catalyst in and running and complying by January 1 with the NOx limit?
Yes, the intention and expectation was that source rata would be completed.
So when you were informed that that catalyst would not be adequate to meet the ammonia slip, then you had to put a separate PO to get a revised catalyst, correct?
That is correct.
Okay. And that was November 30th, we were told about the interim. You don't have a data. We can get, I'll ask the district staff if the date when the draft permit was sent. The thing is, we're trying to find out if you were diligent in applying once you knew that, but I think the board's consideration and mine too is you're seeking, at least the proposed condition is for both 1 and 2. 2 is already under a variance, and if anything, you're not, you need a modification on 2, but and 2 is not in operation right now, so it's not in violation or imminent in violation until you operate. Even when you operate it, it may not be in violation because you're putting the catalyst, correct?
That is correct, but we cannot demonstrate compliance by 12/31.
No, yes, because it's not operating.
That is correct.
Yeah, okay.
But I don't believe that rule was cited in the first variance.
No, it was not, yeah.
Why don't we do this? It's a quarter till. Let's take a 15-minute break. And I'm going to ask the district if you can gather any information that's going to be helpful to you, whether it's the permit, the draft, whatever it is, so that we can go forward. Because right now I'm feeling like we're missing so much information. We're looking at number 2 for a different reason. Whatever you think that you need to get the information, where you need to get the information from, I would like you to be able to do that. And I'm understanding Ms. Manwaring is most likely on vacation.
I will do what I can, and I will try to reach Ms. Manwaring if that can be of any assistance.
Yeah, because as you said, it's possible to have a variance on the same piece of equipment covering different rules, but I just make sure that both parties understand that's what we're doing. If that's what you want to do, just make clear of it.
And we do understand that that is what we were doing, because I did understand that Ms. Manwaring was here on the RATA issue. I'm not sure of the date of that, but I don't have the specific details of that. So I will try to gather in 15 minutes or so.
Well, if you need 20 or more, take it, because we need to know. So if you're going to be maybe 20, 25 minutes.
The honest answer is I don't know.
Yeah.
This is vacation period for a lot of people, and so I don't know the success I will have being able to reach her.
Well, okay, but not just reach her, but whatever's in the file.
Exactly.
And also I want them to understand what exactly is occurring here. I'm not sure that they do.
I'm not either.
So maybe talking to the other party would be helpful. At
Thank you.
least 20 minutes. We're off the clock.
Thank you. Do you have a consultant?
We're back on the recording, Paul.
Okay. Madam Chair, I gathered as much information as I could during the break, and I spoke to the petitioner, and I believe that they are prepared to give more information that might help this board. If I may just ask one question to get them in the right direction.
Okay.
Thank you. I'd like to ask, when did you become aware, in terms of the timeline, that you might need a second variance?
November 30th. And after the first variance was that's all.
So at the time of the first variance, you only knew of that variance that would be necessary. Is that correct? Did I state that correctly?
That is correct.
So can you briefly take us through the timeline? No, excuse me, I withdraw that question. Was there a reason that you did not include the information about the litigation in the first hearing?
I didn't believe it was relevant during the deliberation.
Okay. Thank you.
Okay, just an FYI, any information that goes to any type of a effect on the operation of your business, that you're utilizing permitted equipment, we always want that information. Because we don't know, really, you know, but we don't know, obviously, nor does the district know the whole story of what's affecting your equipment
Right.
in operation. And because it's permitted, of course, the AQMD needs to know all of that.
Okay.
So just an FYI for future reference.
Thank you.
Okay, so I think we were
Yeah.
asking
Yes,
questions.
Madam Chair?
Yes, Mr. Ali?
Yes. So it appears as if the petitioners are not in violation right now. And to be more efficient and have a greater sense of clarity with respect to the overall process, and to allow the district an opportunity to confer with other attorneys who may have been involved in previous matters, can we continue this to the second or third week of January? We have a hearing on the 16th, I do believe.
18th.
18th, which will allow ample time. They're not in violation today.
Well, oddly enough, Mr. Ali, that was a question that Mr. Pearman was going to pose, as well as, had there been more days of the year, obviously, I think I would have continued this to another day for exactly the reasons that you're stating, because I don't feel like we have all of the information legally in front of us. But I'm going, and
Madam Chair,
did you want to ask?
Yeah, if I may add, Madam Chair, they will be in violation for turbine number 1 as of January 120. Turbine number 2 can be done at a later day. They can come in for a modification of the existing variance and get, because they're not in violation of that, they're not operating. But they need the variance coverage as they've requested for turbine number 1, because they need to operate that in violation of the rule. So turbine number 1, they need the variance, and we need to hear it if we go to that, if you find the merits.
Mr. Pearman?
So since I brought it up, if they agree with that they don't need the variance now for turbine 2, since it's not operating, we could just hear it and issue conditions if we find good cause, et cetera, in the 6 findings for turbine 1 only, and just segregate out turbine 2 at this point, which might simplify things and some confusion. I'd ask the parties if they would agree, if they would be agreeable to that, and we could proceed.
Excuse me, Mayor.
Yes, go ahead. We're going to go off the record for about 5 minutes. Okay, we were up here, in the midst of asking questions. Mr. Bella, did you have another question?
Yeah, just so clear, so are you going to propose amending the petition so to include only turbine one at this, for this hearing? For the interim and variance, and come back later if you need to for modifying the existing variance for turbine two? I'm sorry, yeah.
Sorry, I was just trying to.
No, yeah.
Rephrase for it.
Yes, we're good with that.
Okay,
I had a follow-up question. In your petition for turbine one, you said you not operate more than 240 hours a month.
Yes.
Is that hard and fast? Is that normally, is that the case? Or if I were to propose a condition to limit you to 240 hours a month, is that going to be an issue?
No.
No. And
Can I explain how we could derive at that number?
Sure. Yes, please.
So that number is derived at a rate of 8 hours a day for the month.
Oh, okay.
And that's based on our experience, worst case, kind of what the grid would demand of us outside of solar hours.
Okay, I think that clarified the next question I had was, but because you're coming for a notice hearing on the 18th, whether you're not operated until the 18th, but it looks like that's based on 8 hours. So you could be called at any time to generate power next month, in January, correct?
That is correct.
Okay, all right.
which is my concern. I agree with, had we had more days of the year and this were not the end, I would have probably continued the whole thing until, next week or whatever. But the fact remains that we have to take a look at this now, for your sake, as well as the sake of the public in reference to emissions. But if we take two off the consideration for today, I think that makes a lot of sense. But I also am thinking of what we went through last year in reference to storms. And it was during this period of time through January that it did occur. So that then that you will only then be able to produce, if anything, less than half of what you did last year during possibility of doing that this next year. But that seems to be the only route that we can take from this end. So I just want you to be aware of that. Yes.
So the harm to your facility would be financial, correct?
Correct.
But what risk is there to the environment then if you only have 240? Is there a potential risk that you're going to have if you're regimented to that number? Is there the possibility that the environment may need more than that?
If I can interject,
Oh.
let me rephrase what I said, that they would be one of many, okay, that could be called upon to be deployed for demand. However, it's a possibility that they will not be able to produce as much as they did last year, and or what they may be called upon to do, to provide. So I just want them to be aware of that. I don't see it as harm only in the sense of having more kilowatt hours available to the public, not an environmental one.
Okay.
It would be power, not emissions.
Thank you.
Anything to say to that?
I-
Coming from the electric industry, that's why I'm trying to
Right,
explain it to
right.
the
So-
others.
I don't really understand the question.
Well, the question was, I wanted to ask, are you aware of what we just discussed? That you would then not be able to, during the period from now until we get the other variance,
January 18th, 2024.
January 18th, that it's a possibility. Are you aware of that possibility?
That we cannot run
That you will
the
not
max
be able
load.
to produce as much as you did last year, and that you would be, and I don't know whether you need to notify the ISO or not, that you're not going to be able to produce what you normally have in the past? Do you know that you need to notify them?
We do not. I don't believe.
Okay,
We're a peaker plant.
right. You're a
So
peaker plant. So in other
it's-
words, you would be called at the,
We're not called to run 24 hours.
correct, you're not base load.
We're not base load.
Right.
We're
You-
not a base load
Yes.
facility. And so we only run during that high peak demand,
Correct,
5 PM to 9 PM.
right. But my question then is, even though you are a peaker plant, which I'm aware of,
Mhm.
and then you're not going to be able to, you're not part of the base load anyway.
Right.
Do you need to contact the ISO and let them know that you will not be able to provide full capacity as you have in the past? Are you required to do that? Do you know?
I do not know.
Okay.
We have to provide capacity overall?
Correct, but I'm talking about notification.
No.
Okay. All right, that's good to know. All right. Any other questions? Mr. Ali or Dr. Abraham, do you have any questions?
No further questions.
I don't have any questions. I'm just curious as to how are we proceeding now?
We are going to eliminate number 2, correct? Turbine number 2 for consideration in this hearing, and we are going to only look at turbine number 1.
Fair.
Okay, all right,
That's good.
so are there any other questions from any of the board members?
Just, we are still in the good cause finding.
We're still in good
Adjustment,
cause,
right.
yes.
And towards a good cause, I don't know if you, my earlier question was when in November were you notified that your catalyst needs to be changed? You have a date? Did you find out, or the draft permit?
We do. The draft permit was issued on November 10th, and we were notified of it on November 14th.
14th, okay. And then, and November 30th was when you advised you should file for interim.
That's correct.
Okay, all right, thank you.
Any other comments or questions from the board members? All right, with that, that satisfies all of the witnesses that you were going to present. Are there any other comments from Mr. Olmsted or your witness, your brother?
No, we're good. Thank you.
Okay, thank you. All right. Nothing else, Mr. Pearman?
All right.
Okay, all right. Okay, with that, we can go ahead and take your last closing statement on good cause from the petitioner, Mr. Olmsted.
Okay. So I believe we've made good cause with reasonable effort in timely manners to when we were notified of things, given the circumstances that we're in. If we missed deadlines, if we should have done X and did Y instead, there's no malice on our part. It's acting in good faith on diligently, timely on the very darndest we could do. So, with the notification on November 14th to getting a meeting with AQMD to being here on December 28th. Pretty quick timelines to, albeit not ideal, but we are doing the very best that we can. Thank you.
Thank you, Ms. Pruitt.
Thank you. Based upon the explanation of the timeline and the notification that they had from the district is not opposed to the finding of good cause. Thank you.
Thank you. Okay, we can go ahead then and start deliberation on this. Mr. Pearman?
I think we can find good cause due to their corporate stalemate. They really couldn't take any actions to look at the turbine repairs and the need for the catalyst until later in the year. And then it didn't follow naturally that they'd have to comply with the ammonia adjustment till they submitted the permit modifications and discussed it with engineering staff. And once they did that, realized the additional work needed and the delay that might encompass, they did timely come to the district to seek the variance. So I think they did submit it as soon as feasible. It's likely we can find the 6 findings. Denying this would, I think, be adverse to the quality or be unreasonable imposition on the petitioner's activities, which indirectly is in the public service, given their backup status as a power supplier. So I would find we could find good cause.
Thank you, Mr. Pearman. Mr. Balagopalan?
Yes, I too can find good cause, and I'll go through the 4 findings. They will be, as of January 1, for turbine 1, they'll be in violation of 1134, the NOx ppm limit, because they don't have the right, the catalyst is on order, they won't have it till March 24th. So there's a violation of that rule 1134. That circumstances leading could have been reasonably avoided. And I think we heard some of the issues about corporate issues, but I think also they were not notified till November 10th. They got the draft permit regarding that they have to change the catalyst. So even though they had already, in a timely manner, ordered March 24th, March timeframe, the catalyst, they had to then revise the PO to get a better catalyst that'll meet the NOx and ammonia limit. And then once they knew, were informed that you should get an interim variance on the 30th, they filed, I see from the timestamp, December 5th, their application for the interim variance was filed. So, yeah, they could have done it sooner, maybe on the 14th, but I think they probably didn't realize until they were explicitly told you need to file for a variance. But once they were told, they did diligently file. So I think they were diligent in petitioning, and the denial of the variance, it will have an impact because they asked to on demand provide power, during the storm or whatever it is, and so they've been doing that as a peak plant, basically operating as a bigger plant, even though they're not really a peak plant. So I think, yes, I too can make the 4 findings, and we can find good cause and move to the next phase for the variance, interim variance.
Thank you, Mr. Balagopalan. Dr. Abraham, do you have any comment?
No, I agree with both Mr. Pearman and Mr. Balagopalan's assessment of the good cause findings. Thank you.
Thank you. Mr. Ali?
Good cause has been established.
Thank you. I also agree that good cause can be found based on the information that we were able to finally get from both sides. With that, I'm going to go ahead and ask for a motion.
I'll do it. So in the matter of Shadow Wolf Energy, case number 6244-2, I move that we find good cause to proceed to an hearing for an interim in absence of notice to the public based on our discussion and ability to make the findings for good cause.
I'll second.
Thank you. Is there any discussion on the motion? Okay, with that, let's take the vote. Mr. Ali, how do you vote?
Aye.
Dr. Abraham?
Aye.
Mr. Balagopalan?
Yes.
Mr. Pearman?
Yes.
And I also vote aye. So unanimously, we can go on to the next phase, which it's for the 6 findings. When you do make your opening statement, if you can please refer to those 6 findings so that we can also establish that as well. And with that, I'm going to formally ask again, who's here on behalf of Shadow Wolf Energy? Okay. Did you hear my question? Who's here on behalf?
Adam Onstead, CFO, Shadow Wolf Energy. That's OHNSTAD.
Okay, and on behalf of the district?
Stacy Pruitt for the executive officer.
Okay, and I don't believe we have any exhibits in regards to this. We will move all of the previous testimony on the record to this as well to be incorporated. Also, let's see, there are witnesses, and do I need to ask them to take it a second time? Yeah, no. Okay, so we will also recognize the fact that the previous individuals who took the oath are also on record And we will accept that as well. So with that, we can go ahead and go to your opening statement. And who will be providing that?
I will, ma'am, due to Zachary Onstead, due to easier to read and help outline. for
Okay.
the
And your spelling of your name again and your title.
First name Zachary, last name Onstead, Ohnstad. My title is Cogen Supervisor at the power plant for Shadow of Energy.
Okay, proceed.
Starting with the first finding, we would be in violation come January 1st if this interim was not recognized due to the condition. If we weren't, again, onto that arbitrary unreasonable taking of property.
Yes, what we haven't done is we need to have Ms. Pruitt give her opening statement.
Oh, I apologize.
No, my apology.
Was that the balance of their opening statement before I begin?
Did you have something else to add to your opening statement? Okay. Do we want to restart that? And add to it?
Just to, yes, if I could please
Okay.
add to it. We're requesting variance from a number of rules related to the NOx catalyst that needs to be proven by January 1st. And we'll go through the timeline again and show that we've taken efforts to do that, and that there's, as an energy provider, there is a reasonable chance or remote chance that we are called to run, and we would like to protect that for the public. Thank you.
Thank you. Okay, Ms. Pruitt.
Thank you. The district is not opposed to the granting of the variance, given the information and including the changes, the amended elimination reference to turbine number 2. We are not opposed.
Thank you. Okay. Now you can go ahead and start with your testimony.
And we apologize for the bit of chaos over here.
That's okay. You're new to this game. We understand that.
All right, I'll start from the top again. Let's see. So it states with the first one, if the petitioner for the variance, that the petitioner for the variance is or will be in violation of any rule or regulation. And if it wasn't granted, yes, after January 1st, we would be in violation of the rule 1134. Due to conditions. Could I have a second to have Adam understand what this is and read it, and then he could be the one to voice it?
We'll give you 5 minutes.
Thank you, ma'am.
Okay, we're off the record for 5 minutes. We are back on the record. Okay, you can continue your comment.
Okay. So Zach already spoke to the rule 1134 that we will be in violation of come 1/1/2024. Additionally, if the variance was not granted, the taking of property, albeit or potentially money, potentially the asset itself, could take place if forced by the grid to operate out of compliance. Our efforts as a company to address this include the curtailment of operations, meaning 0 voluntary runs, 0 testing, outside of any required testing, and no voluntary runs, only operating at emergency dispatch demand, essentially. And we have no issues with reporting, monitoring. Our SIMS is live. The reports are going out still, so we have no problem reporting as needed to anybody involved.
Okay, thank you very much, Ed. That completes your comments.
Yes, please.
All right, Ms. Pruitt?
Could you please state again, just so that I understand what you will be in violation of should you not be granted this variance? What rule?
Rule 1134, requiring a proven source rata of compliance with the NOx, ammonia slip, and other emissions coming off of turbine 2, due to, and we would not be in compliance as the catalyst is not installed, the new catalyst.
Okay. And is there anything that you could have done to help alleviate this problem since the first hearing in October?
No.
Okay. And if the variance is not granted, what cost would this be to you, if any?
It would jeopardize the contract with the Cal ISO. And it would subject us to penalties if called upon and required to run, I'm assuming, and we'd be operating out of compliance and issued NOVs, and obviously not something that we're trying to do.
Okay. And if the board were not to grant this variance, would it help reduce the contaminants at all? Do you believe that there's a corresponding benefit to reducing the air contaminants if the board were not to grant this? Is that not clear? Let me rephrase. If you do not receive a variance here, is there some benefit that you can see to reducing air contaminants?
No.
Is there any way that you could curtail the running of the equipment in lieu of obtaining this variance?
Not entirely. The voluntary portion, yes. And we have already done that.
I'm sorry, could you explain your response?
The power plant could operate, in theory, outside of demand by the grid. However, the operating profile has been shifted to not include any of those tests or running components that are not specifically ordered required by the grid for their power demand need. So
And-
that is the only time we would run currently.
And how does your is it uploading assist the grid or the grid or the environment?
So it's a stabilizing factor for the power grid. It's outside my expertise. We simply act when called upon.
Okay. And do you anticipate any excessive emissions during this period of the interim variance?
If called upon to run, I guess that would produce emissions.
Well, perhaps I should withdraw the question and re-ask. Will you do as much as possible to reduce excess emissions during this period?
Yes.
And will you monitor the emission levels from the source as requested by the district during this period?
Yes.
No further questions.
Thank you. Okay, board members, Mr. Balagopalan or Mr. Pearman, whichever you prefer.
Sure. Mr. Armstead, I think in responding to AQMD's question about what rules you're seeking relief from, you referred to turbine 2, but I believe you misspoke and meant turbine 1, because I understand you've on the record withdrawn turbine 2 from the requested coverage of this interim variance. Is that correct?
That is correct.
Okay. And have you read Exhibit A, which is the interim variance conditions proposed by the district?
Yes, sir.
And with the exception of the reference to turbine 2, are you in agreement and stipulate to those conditions?
Yes, sir.
Thank you. Nothing further.
Mr. Balagopalan?
Yes, Mr. Onstead. Just to clarify, you are okay with accepting a condition to limit the operation to 240 hours a month?
Yeah, I believe it's good faith.
Okay.
I mean, it's a compromise, but it's
okay.
Short of asking for every hour of every day.
Okay.
Right.
Right. And in your petition, it indicated that you will have an excess emission of approximately 136 pounds a day of NOx. And that's your understanding? That would be the excess emission during the.
Yes, that is the maximum NOx emit, and that's what it would be based off of, the maximum for the day.
Okay. Now, the rules you cited with 203B, 2004 F1, 3002 C1, and 1134 D3, you didn't include ammonia. Will you be in violation of the ammonia slip limit, and do you need a coverage? And if so, what permit condition is that you need relief from? Are you requesting relief from also the ammonia slip limit?
I do not believe so, due to the last source test showing that we're around 2.5 tons, low levels of it, and will not be needing the variant rule for that.
Now, you testified earlier and in your petition that you are purchasing a different catalyst because to reduce ammonia slip. So, so you're sort of contradict. Are you saying you don't need relief until you get the new catalyst in?
The new catalyst is for the NOx 2 ppm and did not satisfy the ammonia slip until the change order was submitted.
Right.
The updated catalyst slip component. The current catalyst does not have excessive slip. Is that correct?
Correct.
Oh, you mean on your permit, it doesn't have a slip, a condition saying you're limited to a certain amount of, oh, let me rephrase that. Were you provided with a revised draft permit for turbine 1 and specifically turbine 1?
Yes, I have a revised permit That was hand delivered to me today.
And did that revised permit reduce the ammonia slip number from your existing permit, previous permit? Previously, you were probably at 20 ppm.
Yes.
Has that been
It's
reduced down
reduced to
to
5.
5 ppm? So as of January 1, 2023, because you don't have the new catalyst in, you would probably exceed that permit limit. Is that a true statement, or?
I'd have to get with the engineer myself.
Okay.
You might know that.
I don't think we would be in violation due to seeing the values, it would be at 2.5, but it was the back, so it changed the. Could you re-ask that
Okay,
question?
let me ask you, you have an opportunity, let me put it that way, since you're asking for relief from a number of condition, to add another condition to requesting relief just to be, as part of the variance, and specifically that permit condition. And so what I'm seeking is, if you need relief from that specific ammonia slip condition and what that condition number is, basically. If you don't know, I can ask district staff to respond.
That would be great.
Okay. All right. Thank you.
Thank you.
All right. Madam Chair, at some point, Ms. Pruitt can introduce Ms. Monica Fernandez here, and I can ask her the question.
Yes, the district introduces Monica Fernandez Neal, supervising air quality engineer we have no questions of her, but if the board has questions.
Yes, and just for record, Ms. Neal and I have worked many years together. So my question is.
I would just like to confirm you were sworn this morning and you did.
I was.
Thank you.
My question, I think you heard the question, is there a permit condition that limiting the ammonia slip?
They have an emission, a BACT limit in their facility permit that was just approved 2 days ago, came off of EPA, and the current ammonia slip on their PC is 5 ppm.
5 ppm. So what is that permit condition number? Do you know? Do you have that?
The condition number that we have is not in relation to the 5 ppm because the BACT number is their emission limit. It is part of the equipment description, part of section H. However, we do have a source test condition, which may be what you need. And the source test condition is D 28.1, and it does make reference to the BACT standard, not via the actual number, but the rule.
Right. And okay. And let me ask you the question. Do you think they need relief from that ammonia slip standard during the duration of the variance?
I do not know where their current ammonia slip is. I do know that they have done source testing. However, I have not seen what the current slip is. I do know that the quantity that Zach was stating was their annual emissions of ammonia last year. 2.5 tons.
It's not ppm. Okay.
Not ppm.
And but prior to the permit that was just issued, approved by EPA, their limit was 20 ppm ammonia.
Correct. In section D,
okay.
Currently both are at 20 ppm. Section H, 5.
Okay. All right. I think that answers my question. And I have no further question. I would like to go back. Just, I'm not trying to force the condition on you, but do you need relief from that condition? If you don't need it, I won't propose it, but it's up to you. From D 28.1.
I would like to propose inclusion of D 28.1.
All right, thank you. I've got no further.
Thank you. Okay, Dr. Abraham or Mr. Ali, do you have questions?
I don't have any additional questions at this time.
No questions.
Thank you. Mr. Pearman, do you have any questions? Okay. All right. With that, we have satisfied asking your questions of the witness from both the council as well as the board members. So we can go on to your final statement of why we should vote for the variance for the 6 findings, inclusive of the 6 findings.
Thank you very much. We will continue to act in good, reasonable manner. We will report. We will stay compliant. We will act timely. And we will conserve our emissions with limitation of any voluntary running, the best of our ability to continue providing power to the constituents that, take that power. And, I think that concludes my statement.
Thank you. Okay. With that, we can go ahead and go to, I'm sorry, Ms. Pruitt. This has been such an unusual case, unusual day.
He most certainly has. The district does not oppose the granting of the variance. And we would just like to make sure that the record is clear that turbine number 2 has been eliminated from the request. And based upon that, based upon the testimony and the documentary evidence and the conditions, the district finds no opposition.
Okay. Thank you very much. All right. We can go to questions.
No, I think we're going to deliberation.
Yes,
Yeah,
deliberation.
I believe I can make the 6 findings to grant the interim variance. The petitioner will be in violation of 203B, 2004, F1, 3002C, 1, and also permit condition D28, 1134, D3, and D28.1. So that's the first finding. Non-compliance beyond the reasonable control, as we had heard that they had to order a new catalyst to meet the lower ammonia ppm limit. They were on track to get the catalyst for the for the NOx, but then they were informed that they also need to reduce ammonia slip down from 20 ppm to 5 ppm, I believe. So that that's it's sort of beyond their control until they get the new catalyst and install it. So non-compliance is beyond the reasonable control, and closing or taking without a corresponding benefit. Now their excess emissions are not minimal. They are during this variance period. It is approximately 134 pounds a day, but the harm to petitioner outweighs the benefit to air quality. If the emission associated with variance are eliminated as a result of denying the variance. In addition, I think the larger public that may need the power and they call to provide it, that will get affected too. They have given, petitioner has given consideration, I think we heard from Olmsted, that Adam Olmsted, that they're willing to limit the operation to 240 hours max a month and not do any additional testing or any other. So that really provides a curtailment basically during this interim period. And so that will also reduce excess emission to the maximum extent possible. And the last not least is they have the sensor operating that will monitor the NOx emission during this period.
Thank you. Do we have a second?
Second, Ali.
Thank you.
Well, I didn't make the motion, so I just made the 6 findings.
Yes.
So
We're not quite there, Mr. Ali. It sounded like one, but we're not quite there.
I will be happy to make the motion
Okay.
if there's no other comments. So
I think there's no other comments.
No, I agree with the findings as stated by
Yes.
Mr. Bullock.
I do too, especially the fact that what you had to go through in reference to the partner situation, as well as the need, whatever it is, as a last source, if you will, to the grid. Should there be anything similar to last year's storm, which is very possible. But all that being said, I still think that you are a worthy partner within the ISO and need to be online and available to contribute to the grid as much as possible. So I also agree with the 6 findings. Okay.
All right, I'll make the motion. In the matter of Shadow Wolf Energy, case number 6244-2, I move that we grant an interim variance commencing January 1, 2024, and for 90 days until a notice hearing, which is scheduled for January 18, 2024, whichever occurs first, from Rules 203B, 2004 F1, 3002C1, 1134D3, and permit condition D 28.1 for the equipment identified as turbine number 1 only, device number D1 and application number 634713 for the equipment located at 251210 Highway in Santa Clarita, California 91321. Excess emission during this period will be approximately 130 pounds. There's no quantification at this time of the excess ammonia emission, but hopefully when they come back during the noticed regular variance, they may have hopefully provide some calculation about the estimated excess ammonia emissions during the period. With that, and I think the conditions are as provided in Exhibit A with the removal of the condition for turbine number 2, basically. And everything else will stay as is, with the addition of the one condition. Oh, I'm sorry. Let me get that condition, because we have to give a condition number for the new condition. So where to insert it? So I do with my number, and I will find it in a moment.
Madam Chair, while he's looking for that, can the clerk, once he's done, can the clerk read back the motion? Because there seems to be a lot going on, and there's a little confusion with respect to what he stated.
The condition is for one of the findings is you have to curtail emission to the maximum extent possible. This condition satisfies that requirement of one of the 6 findings. So that's
right. But if you can read the complete motion, because you've offered a motion, then you've offered extraneous material and supplemental commentary, that I want to make sure it's clean before I vote.
I'm trying to make it so that the clerk also knows where we are inserting that specific condition number into the proposed condition Exhibit A. So I would include that as condition number 4 and renumber the other condition subsequently, and remove any reference to condition 8 to 13 in the appendix Exhibit A.
So, Madam Chair, can the motion be read back by the clerk?
Yes.
Thank you.
Madam Clerk, can you read that back?
I don't take, we do a
Dictation.
recording, so I can't stop the recording to read it back. I'm sorry, I'm not able to read back his motion.
Let me,
One more
Madam Clerk,
time.
is it clear what I've just proposed, and as far as where to insert the proposed condition?
Yes, I do have that, and I do have it in the recording.
Okay.
So I am able to articulate what you have said as number 4, then renumbering, and then we want to strike number 8 through 13.
Yes.
And renumber from that point.
Yeah. Yes.
I do have that information.
Okay, Ali seconds the motion.
Okay, any discussion on the motion? All right, let's take a vote. Mr. Ali,
Aye.
Dr. Abraham,
Aye.
Mr. Pearman,
Aye.
Mr. Balagopalan.
Yes.
And I also vote aye, so it's unanimous. We do vote that you will be granted this variance, and we will see you again on the 18th. Thank you so much.
Thank you all very
Yeah,
much.
thank you very much to staff for all of the hard work that you did so that we could come to this conclusion. I appreciate that. We all do. Thank you again.
Thank you, ladies and
Okay,
gentlemen.
this matter is closed. We're going to break for lunch. I know we want to take a short one. However, based on the fact that the cafeteria is closed, we are all going to probably have to order something and or go pick it up. So I'm going to give us until 1 o'clock. I think that'll work out. Or as close to it as possible. And we are off the record.
I am.
So back at 1 o'clock, Madam Chair.
Until 1 o'clock, yes.
Thank you.
I'm sorry, I didn't hear you.
Mr. Shea, would you like to be promoted to panelist? Okay. And then who else from your group would like to be moved over, please?
Thank you. I'm testing my microphone now. Will you please let me know if you
Yes, I can hear you. Great.
Thank you.
Let's test your video, please, if you can turn your camera on. Perfect. I was told some others from your group might need to be promoted, Mr. Boyer or Gamut.
That would be Joseph Shepard. He's the plant manager. We'll also be speaking today.
Okay, let me move him over. Great. Mr. Boyer, if you could turn your camera on, we'll do a test with you, sir.
Okay. And I'm going to have to beg a little. I'm not as familiar with Zoom and getting cameras on.
Be in your lower left corner. Says stop or start video. And you'll see a red line through the camera, and you simply turn that on or off. Here, looks like you've got it.
Oh, I do?
Oh, no, Mr. Boyer. Lower left corner.
Yeah, all I see is the mute button.
Next to the mute button, you should see stop camera or start camera.
Yeah, no, I don't.
Mr. Shea, maybe you can help him a little.
You're on mute, Mr. Shea. Mr. Boyer, are you on your phone or are you on a laptop or desktop?
I'm on a desktop.
And it has a camera?
It does have a camera, yes.
Okay.
It
Yeah.
does have a camera.
Yeah.
It has a camera, but on my screen, all I see is on the far left corner, I hover over a microphone emblem that says mute.
Yes.
I can click that and either mute or unmute myself, but I do not see a emblem, and it's through web that says I don't see a camera or anything like that next to the.
Right. It being that you have a desktop, it's going to be an outboard camera, so it might appear in a different spot. You have any ideas, Mr. Shea, where that camera might be?
Maybe, possibly, if you have a scroll, if you have settings on the bottom of your screen where you can see everybody's pictures, there's the mute button. And then if you look towards the right, there may be 3 dots. No, that's, let's see.
More?
Yeah. Is there anything under more that gives you anything for a video?
Yeah, I don't see a video. And it may just be my ignorance with this software.
Is there an up arrow on your microphone that may give you more options to turn on the camera?
Yeah, there is there's this, you select a microphone, select a speaker, leave audio settings. I do not see anything there that says, so it may be something with the settings on my, I don't have the Zoom app. I have Zoom. I wonder if I have Zoom. Well, let's see.
A web-based application, perhaps, and also if the Zoom whatever interface is not recognizing the camera driver or the
Yeah.
Right, doctor. Correct.
Yeah, I do have options, but none of them are for camera on.
Kind of a camera icon.
No camera icon.
Yep.
Do you know if you are in the gallery view? If you look in the upper right-hand corner, there's a tab to sign in, and there's a small 3x3 grid that says view. If you switch to gallery, that may make a couple other options appear.
Sign in.
Next to sign in, there may be a view option.
No. No, it's just an option to enter full screen or exit full screen.
Are you out of full screen or are you in full screen?
I think I am in full screen right now. I've switched back and forth a couple times. Are you still there?
Yep, I'm here. I'm still
Okay.
looking at these options. I wonder.
Is there a way through this that you can take control, JT, and see what I'm?
Would you be all right with, this is a bit, excuse me, it's a bit crude, but would you mind taking a picture of all of your options with your phone and texting it to me? I'm not sure if I'm able to take.
Yeah, there is not a lot. I'm going to be honest. There's not. I don't see any options for. Okay.
I'm looking for it as well.
And what is message 2? I'm going to send this to you right now. I just texted it to you.
So I would try pulling it out of the full screen so that it's a smaller window first.
Okay.
And then also, if you have a setting, that should give you a little bit more options when you scroll to the bottom and top of the screen.
No, it does not. If I go to the top, customize live streaming service.
Is requesting for one profile.
You don't want to do that. That's only what the host can do, and I did that for the Zoom, YouTube.
Okay.
I'm gonna leave that one alone.
Yeah, I don't see any. Let me look through the toolbar. The raise hand option, and again the mute option and leave option.
Paul?
Yes.
According to the board, as long as we can hear the witness.
Yeah. Okay.
That'll work.
Okay, great.
Any that can appear with their cameras, we appreciate it, but being able to hear them,
Need to
we
get
can go
going.
ahead and move forward.
Great. So Madam Counsel Abrams, that'll be fine, right?
I'm sorry?
Repeat that, Paul, please.
That we can go forward with Mr. Boyer just speaking as the clerk noted.
Yes, that's correct.
Great. Let me start the recording. Okay, Madam Clerk, Madam Chair, we're good to go whenever Madam Clerk is ready.
I'm ready.
Okay, good afternoon, everybody. This is the South Coast AQMD Hearing Board. Today is Thursday, December 28th, and we are here for the last item on the agenda, which is Colton Power LP case number 6167-3 in regards to the short rule and 203 plus 1134, 2004, and 3002. And who is here on behalf of Colton? Since we are doing this via Zoom.
My name is Jonathan Shea. I may be showing up as JT, but I'm going to be representing Colton Power, and I will also be testifying as a witness, as will the plant manager, Joseph Shepard.
Okay, Mr. Shea, what is your title? Please spell also your name both names, and also we will be administering the oath in a minute or so, but go ahead and if you can give your name and your title.
Jonathan Shea, Environmental Health and Safety Specialist. And both Joseph Shepard and I will be taking the oath today.
Okay. And on behalf of the district?
Stacy Pruitt, the executive officer, and I've got witnesses here that I do not plan on calling, but I would like to make available. Avelino Revilla, who is an AQ Inspector 2. I've got Philip Nguyen, AQ Engineer. I've got Thomas Lee, Supervising Air Quality Inspector, and Adan Velasco, Senior Air Quality Engineer. If you could please stand to be, are you going to?
I'll call it, yeah.
Okay, thanks.
Okay.
You may want to mention the other two members.
Yes, we voted earlier. We have two members that will be participating telephonically. Oh, I take that back there. One is going to be via Zoom also, and then I think Mr. Ali, we got him on also? He was, okay, good. On Zoom, all right. So I don't think we need to vote again, but since we did at the beginning of the hearing today, earlier. All right, so with that, we can go ahead then and proceed unless there's any objection to our participants, our board members participating in that way. Do you both agree to accept that, Ms. Pruitt and Mr. Shea? You have no objections?
No objection.
Madam Chair, what is the what is the request?
To accept both you and Dr. Abraham. Since we voted on it earlier, I'm asking them if they had any objections.
Yeah, but they legally have no objections. They can object. Both of us are attending pursuant to provisions of the government code. So whether they
Correct,
object or not has no
correct.
bearing.
Yes, but I still have to state that, Mr.
No,
Holly.
you don't have to state
Anyway,
that.
why don't we go on? We'll continue, then we can have that discussion later.
Yes, yeah, I want to state the record, make it clear.
Okay, thank you. All right, with that, let's go ahead and start with having members who will be testifying, whether it's on behalf of Colton Power and or on behalf of the district. If you can please raise your right hand. Okay, under penalty of perjury, do you swear to tell the truth, the whole truth, and nothing but the truth? Okay.
Madam Chair, we need the members for Colton Power. They are not showing on camera.
Okay, they can answer verbally that you have taken the oath. Mr. Shea and Mr. is it Boyer?
Shepard.
There also was a Boyer that showed up.
That would be Shepard.
Okay, so there's three of you?
I can take an oath, and I'm not planning on testifying, and it's not needed, but I can say affirmative, I've taken the oath.
Okay, and Mr. Shepard?
Yes.
Oh, there you are. Okay, thank you.
And
And then Mr. Shea.
Yes, I do.
Okay, as far as exhibits are concerned, we have the one from Colton Power, which we will be identifying and calling that number 1. It is the borescope inspection and photos of the inner tube. That will be 1. And then we also have conditions from the district. And actually, I think I just did that in reverse. Oh, no, that's right. 1. And then from the district will be A as an apple. Okay, and I believe those are all the exhibits. Is that correct, Madam Clerk?
that is correct, Madam
Okay,
Chair.
thank you so much.
Madam Chair, you may want to let the other two board members who didn't get it electronically that there was a change in condition 5.
Did you hear that, Dr. Abraham and Mr. Ali? There's a change to the conditions in number 5. The changes, we just received it right before the hearing. And number 5, it's at the bottom of it, it will state, in lieu of the above mentioned requirement, the petitioner may choose to comply with the requirements in Rule 2012 C2D and 2012 C2E as amended on November 3rd of 2022. That's the only change to the conditions.
Okay, thank you.
Mr. Ellie, were you able to receive that?
No, I have no redocumentation in my email.
That's why I read it to you, because I don't think they got a chance to send it to you.
Okay, well, please have them to send it over. I would prefer to have it in my inbox.
Okay,
So I
great.
can confirm receipt.
Okay. We can do that, right? Okay, they'll figure it out. All righty, so with that, let's go ahead and start with opening statements. And is it Mr. Shea, will you be providing the opening statement?
I will.
Okay, so, and have you also looked at the 6 findings that you will be requested to provide? Let me see here.
We received the provisions.
Okay. They have to pay.
Oh,
Yeah,
yeah.
so were you given a copy of the 6 findings, sir?
I'm assuming that would have been in an email. I don't believe so, but let me double check.
I have it. If I may, it would have been a part of the document that was initially meant to go on consent calendar. It contained every part of the document.
But did they receive the copy of the 6 findings?
It was a part of the submission that was sent to them, and I see that at least one of them said that he has it.
Okay.
I have it.
Okay, Mr. Shea, but you're going to be making the opening statement, correct?
Correct.
Unless you have another party make the opening statement, since he has the 6 findings, and since we need to tie our decision to those 6 findings.
I just forwarded to you, JT.
Thank you. I believe
Well-
I've addressed each one of the 6 findings, but let me just double check and make sure that I have this right. I don't want to present something in it. I'm keeping an eye out for it now. Should be any second.
Madam Chair,
Yes.
I was going to say they can make the 6 finding in their closing and summarize that, you know,
But
so
I
if
also
they,
want them to understand what we're looking at and during the hearing, what we're also going to be asking for. And why we're asking those questions. But in any case, have you received it, Mr. Shea?
Yes, these were the conditions, but I believe I've addressed each one of the 6 findings in my opening statement.
Okay, great. That's wonderful. You can go ahead and begin.
Okay, thank you. My name is Jonathan Shea, JONATHANSHEA, speaking on behalf of Colton Power, LP, Drews, which will be referred to as the facility. In consideration of the pending petition for short-term variance regarding combustion turbine number 4, which will be referred to from here on out as D4 or the unit. In early September 2023, my team began our assessment of the conditions of each unit at the site located at 559 Pepper Ave in Colton, California. Permit number 182563. We believed that each of the units on site were in an operable condition and scheduled borescope inspections immediately. Borescope inspections are visual inspections using a telescope and camera to determine the functionality of the units prior to the testing required annually by the AQMD. We scheduled the inspections for late October and early November, the first slots that were available to us. Upon receiving the results of the inspection, we found that the unit was not in a condition to operate safely and began working to determine a repair schedule for the unit. As the facility began reaching out to scheduling contractors, we found that no contractors will be available to conduct necessary repairs for the unit, at least until January 2024. It was at this point, the last week of November, that we received the results that the facility realized that the unit would not be able to operate for the annual ammonia slip testing that we had previously scheduled for the third week in December 2023. This is when we filed a short variance. The 2023 annual ammonia slip test is due by December 31st, 2023, and was scheduled to occur on December 21st, 2023. The test must be completed while the gas turbine is operating. Since we have deemed the unit unsafe to operate, the facility will not be able to conduct the test within the time periods required by the permit and district rules 1134 and therefore 3002 and 203. Therefore, the facility is seeking an exception to the requirements to perform the ammonia slip test within the time period required by the permit and district rules through issuance of a short variance. Granting of this variance will not result in any excess emissions as the unit is inoperable at this time. The facility has no plans to operate the unit until after the necessary repairs have been made, which will be in the first quarter of 2024. The facility has begun scheduling the repairs and also ammonia slip testing for the end of quarter 1, 2024, in accordance with a 90-day timeline set by a short variance, and also in accordance with the shortest timeline that we deem the repairs possible. Thank you.
Okay, Ms. Pruitt?
Good afternoon, Madam Chair and board members. Stacy Pruitt for the Executive Officer. The district is not opposed based upon the previous conversations and the document exchange with JT Shea. However, we would actually ask to reserve our opinion until after, our position until after the evidence is brought forth. Thank you.
Okay. Okay, Mr. Shea, you can go ahead and start with your first witness. And if it is in reference to your exhibit, if you can refer and tell us that you are referring to the exhibit.
Absolutely. Thank you. I will be testifying as the first witness as a narrative, but also including Exhibit Exhibit 1. This was my personal account of the schedule and the events that occurred. As the EH&S specialist, my team was tasked with determining the Colton Power LP Drew's operational status and maintaining compliance with government regulations in early of September of this year. We began by scheduling necessary inspections and testing, reaching out to borescope contractors and scheduling ammonia slip testing for all units as early as September 6th. Because of the limited time available before the end of the year, dates available were extremely limited. The test for Unit D4 occurred on Saturday, November 4th. The facility received the results the same day, summarized in Exhibit A, and submitted to the clerk of the board this morning, and determined that due to extensive damage, the unit is unable to run. If you will refer to Exhibit A, you can look at page 3, 4, 5, and 6. I encourage you to look at these, and even without professional experience in this area, you can tell that there's extensive damage on each one in several different parts of our units.
Is that the end of your testimony, sir?
Excuse me, it's not. The company that came out, the contractors do not make determinations, simply provide a report. If you look on pages 1, 2, and 3 of Exhibit A, you'll see that they also noted extensive damage. I was notified on Monday, November 6th of the damaged unit and our decision to not run the unit until we were able to repair it. My initial review of the proper steps to take the unit out of service was of Rule 2012. And it states that the due date for semi-annual or annual assessment of a major source may be postponed within 14 unit operating days from the first refiring of the major source if it's physically incapable of operating and all the following are met. All fuel feed lines to the major source are either disconnected or opened and either flanged. And I'll stop right there because I want to highlight that it was the incorrect.
One moment, please. Sir, I'm going to interrupt you. Ms. Pruitt, you can't hear him?
Yes, he's reading so quickly that I can't understand what he's saying.
Okay, if you can just slow it down a little bit, Mr. Shea.
Of course. If I may summarize.
Thank you.
When I read.
That's fine if you summarize.
When I read AQMD Rule 2012, I mistakenly believed that all we had to do to take this unit offline and therefore be exempt from testing until we were able to repair it was blank off the fuel lines to the unit and notify the district of both non-operation and then later on when we brought the unit online. On December 16th, I had a meeting with some of our corporate environmental health and safety managers, and I notified them of our plan to notify the district. It was during this call that we determined that my understanding of the rule was incorrect and that a variance was likely required to postpone the testing, not simply notification. We promptly began the variance process, reaching out to the facility inspector to confirm our interpretation and determine the next steps. On November 16th evening, I called the facility inspector, Avelino Revilla, and was directed to speak with the site permit engineer, Philip Wien. It was determined during this call that a short variance would be required. On November 28th, I submitted the short variance to the clerk of the board for review, and the variance was scheduled. Since we have since reached out to contractors and source testing companies to schedule testing and repairs for the unit that we expect to be finished by the end of the first quarter 2024. That concludes my initial statements.
Thank you, Ms. Pruitt.
Yes, good afternoon, Mr. Shea. I was going to ask you, when did you realize that you would need a short variance in this matter? Was that, well, let me ask you.
We first realized that a short variance would be required on November 16th when we contacted our district inspector and permit engineer.
Okay, did I mishear? I thought you said December 16th at one point. Did you mean November 16th or December 16th?
Thank you for asking. I meant November 16th. I may have stuttered.
Thank you. And upon getting that information, when did you take action?
We were able to confirm this at shortly after 5 that evening, or it was the next morning on the 17th, to when I reached out to our corporate manager, and we began setting up a short variance petition. Okay. So that would be action as early as the 17th.
Thank you. When did you complete the petition?
We completed and submitted the petition on November 28th.
Did you happen to speak to any district staff with regard to your petition prior to submitting it?
Prior to submitting the initial short variance petition, I do not believe I spoke with any district staff after we had confirmed that we needed a short variance.
Okay, thank you.
Was that it, Ms. Pruitt?
I may have one more question.
And your facility is a peak facility, correct? Or peak demand facility?
That is correct. Yes, ma'am.
Thank you. Nothing further.
Thank you. Board members? Mr. Pearman?
Just curious, this is a short variance, interim emergency, but you did fill in section 4 of the petition that I'm reading for good cause. So I take it that was just unintentional, and this is not an interim variance request, correct?
Correct. This is not an interim variance. This is for a short-term variance.
Thank you. Nothing further.
Mr. Balagopalan?
Yes, Mr. Shea, good afternoon. I'm looking at the boroscope report, inspection report, and the turbine section says there's severe damage throughout the turbine section. Has that been dismantled? Had to look at the actual, the blades that are affected and so forth, or is it still not yet opened up yet?
Due to the short timeline of this whole occurrence, we've been unable to schedule any contractors to come out and open the unit up yet. These boroscope inspections were simply the first step to assessing the damage and what repairs would be needed, but we've since begun scheduling the appropriate contractors for the repairs and dismantling.
We had, unfortunately, a number of facilities that come with a similar problem, and it seems your timeline is very optimistic because they took months, almost a year in some cases, to do the repairs and do the alignment, come back and install it and do the, the vibration analysis and so forth. So are you're only requesting, you're optimistic that you can, once you remove it, you can assess the damage and repair it and bring it back within 90 days?
If I'm allowed, I would like to refer that question to my second witness, the plant manager, Joseph Shepard.
Okay, we'll defer that. Now, the other question I had is, you are specifically asking from condition for the ammonia slip. What about the NOx limit? Are you don't have an issue with meeting the NOx limit once it's back online? The 1134 has new requirements that said in January 1 of this year, next year, sorry.
At the moment, we're simply filing the petition to extend our deadline for the ammonia slip testing.
Okay. So there is a requirement to do the, okay, you're not operating the turbine right now. Okay, all right. That's all I had. Thank you.
Correct. Thank you. If I may, unless that's part of testing and tuning, but I don't believe that was our concern at first.
Okay, Dr. Abraham or Mr. Ali?
No questions for this witness.
No questions either.
I did not hear you, Mr. Ali. Repeat that, please.
No questions for the gentleman.
Thank you. Okay. Mr. Shea, you can bring on your second witness.
Thank you. I invite Joseph Shepard, the plant manager, to speak.
Good afternoon. My name's Joseph Shepard, or Joe, JoeShepard. I'm the plant manager for San Joaquin Energy and the Colton LP power facilities, including Drew's. In regards to the question for the gentleman.
Okay, before you start that, sir, your title and how long, I didn't hear your title. Repeat that, please. And then also, how long have you been in that position?
My title is plant manager, and I've been in this position for 1 year.
Okay, and you did take the oath, correct?
I did take the oath.
Thank you. You can proceed.
Thank you. To address the question from the board member, the reason that we can have such an aggressive repair strategy is that the previous owners had procured 2 additional units of salvage quality, but still in good standing. Our plan is to use the internal components from those units to repair the D4 unit from Drew's.
Mr. Shea, do you have additional questions for this witness?
Joe, do you remember when you first reached out to the borescope inspectors?
Yes, so upon the transition being completed from the NACE team, and we had the actual notice to proceed for ownership, that's when we started reaching out to borescope contractors to perform this assessment. The nature of the type of units, these are not as widely found throughout the United States. GT10s, they're made from an Italian contractor, Italian vendor. So finding someone with that technical ability was somewhat difficult. So that would have occurred probably around the first part of September.
Thank you. No further questions.
Okay, do you have another witness you need to produce? Oh, I'm sorry. Ms. Pruitt does have questions for this witness.
Just briefly. Mr. Shepherd? Is that
Yes,
correct?
that's correct.
Mr. Shepherd, the strategy, as Mr. Balagopalan stated, is very aggressive in terms of the timeline, in that it is condensed. Is it realistic? So that
Yes.
you wouldn't have to come back and ask for more time.
Our belief currently, we performed follow-up borescopes of the, I'll call them salvage units, and the components internal to those units that match up to the existing unit of damage, unit D4. It's in our best findings that those units are compatible and will accelerate the repair. Our goal is to have the unit removed on the first week of January and have it returned to site the first to second week of February. There's external apparatus that needs to be hooked up, which will take an additional week. And then we would like to test run the unit per the permit conditions and then have it ready to have follow-up testing.
So it's your testimony that you believe that you can accelerate this timeline because you've got a one-for-one exchange at this point? That's your belief?
That is correct. There is actually 2 units that have compatible parts that we have to pull from, and those were also borescoped at the same time. So we believe we have adequate parts to repair this unit once it's removed from the actual compartment.
Thank you. Nothing further.
You're welcome.
Board members, Mr. Balagopalan?
Mr. Shepherd, just to clarify, you will bring the salvage unit in and swap it with the one that damaged, or no, you'll use that parts for the repair?
Correct. Those will be donor parts. The unit and serial number as assigned will stay the same. Only the internal components that are compatible for the repairs will be installed inside.
Okay. All right. Well, follow up to that, the question to ask Mr. Shea also, and to your knowledge, you don't have an issue with meeting the NOx limit of Rule 1134?
Not to my knowledge.
Okay. The question for Mr. Shepherd, but that's okay. I think you answered. All right, thank you. I've got no further questions.
Mr. Pearman?
Mr. Shea, have you read Exhibit A, the proposed short variance conditions that have been presented by the district?
I have them right here. Excuse me. I'm just finding them.
So he did.
Yes, I have.
Do you agree to them on behalf of the company?
I do.
Thank you. Nothing further.
Mr. Balagopalan?
Yes, thank you for bringing that up, Mr. Pearman. I wanted to bring your attention to condition number 5. You see the section that is highlighted?
Forgive me, mine is not highlighted. If you would, quickly mention which line.
I'm not sure. Do you have the latest one? Condition 5, the last sentence is in lieu of the above mentioned. Do you have that language in your proposed condition, revised condition? The last sentence, do you have that?
It doesn't appear that I do.
Oh, okay. You don't have the latest revised condition then?
Madam Chair, may I please, by interlineation, read it so that he can add it by interlineation?
Yes, I read it earlier, but go ahead.
Thank you. I think he may have missed it. I'm sorry. Mr. Shea, on number 5, at the end of turbine is not operating, there is one additional part that reads, in lieu of the above mentioned requirement, the petitioner may choose to comply with the requirements in Rule 2012, subsection C2D and 2012 C2E, as amended on November 3rd, 2022. Would you like for me to read it again?
If you wouldn't mind, thank you.
Nope, no problem at all. Would you like to take it down as I'm reading it, or?
I just want to confirm that I wrote it correctly.
Okay, so it's should read, in lieu of the above mentioned requirement, the petitioner may choose to comply with requirements in Rule 2012 C2D and 2012 C2E as amended on November 3rd, 2022.
Thank you. I've got it.
You're welcome. That is the only change to the conditions as submitted.
So to follow up on my question on number 5, are you familiar with that amendment that occurred on November 3rd, 2022 to the Rule 2012?
I believe so. Before I confirm or agree with it, would you give me 5 minutes to read it over?
Yes, we'll give you 5 minutes. We're off the record for 5.
Thank you. Okay, thank you. Yes, I found it. We agree.
Wait a minute, we're back on the record. And now you can repeat your answer.
Yes, we agree with that addition. Thank you.
One final question on your petition. Oh, sorry. Thank you. Petition in item 24, you're requesting that it says variance to begin on 12/18/2023 to 3/31. You know you are requesting a short variance, which is only for 90 days, correct?
Correct. I was just going to look for that on the variance.
So if we were to grant it from January 1, 2024, and next year being a leap year, it'll be March 30th, 2024. That'll keep it 90 days. Is that acceptable?
Absolutely. March 30th is fine. Thank you.
Okay. All right. I have no other questions.
Thank you. Any other questions from either Dr. Abraham or Mr. Ali?
Yeah, no questions for Mr. Shepherd.
Mr.
No
Ali?
questions from Ali, no questions either.
Thank you. Okay. All right, sir, do you have another witness you wanted to present, Mr. Shea?
I do not. Thank you.
Okay, seeing none, are there any comments, any hands raised from the public regarding any comments for this case?
Madam Chair, currently there are no hands raised from members of the public.
Okay, thank you. All right, with that, sir, we can go ahead and go to your closing statements and keep in mind the 6 findings. You can begin anytime.
Thank you. In closing, I would just like to reiterate that my team made every effort to follow AQMD procedures in a timely manner and to take every step to avoid excess emissions and safety hazards. The facility made sure to visually inspect the unit prior to any operation and decided on a plan before consulting outside agents and agencies, including the Air District, to ensure that our actions would be compliant with regulations. Considering we do not plan to operate this unit until it's been repaired, we do not believe any excess emissions will result from this variance being granted, and no harm to the environment will come as a result either. Thank you.
Okay, Ms. Pruitt.
Thank you. Based upon conversations with staff and the petitioner and the documentary and testimonial evidence, the district's position is that we are not opposed to the granting of the variance. Thank you.
Thank you. Board members, Mr. Balakavan, did you want to begin?
Yeah, I do. I do believe I can make the 6 findings to grant the short variance for this for the repair and for the testing. The petitioner will be in violation of, as they stated, 203B, 2004 F1, 3002 C1, and specifically permit condition D28.1 and Rule 1134 E2C 3, and and non-compliance is beyond the second one, it beyond the control. I think the boroscope study showed that there's extensive damage to the turbine section, so they would have to take it out of service. So, and that's beyond the control, and so they cannot do the test by the end of the year. The closing of taking without a corresponding benefit, since the unit is not operating, there's no emissions and there's no so the harm to the petitioner outweighs the benefit to air quality in that sense, because the emissions are essentially none during this period. They have given consideration curtailing operation. It is shut down until they do the repair. They're fortunate they have replacement parts, and hopefully they can do that within 90 days, but we'll find out once they open it what else is damaged, because I'd see from the report they haven't looked at the exhaust section. Who knows what the liberated blades might have done internally, but if so, they can come back. And also during the period, I think there's a condition to monitor, looking at the excess emission, but since there's no excess emission, the provision to operate the SEMS, is sort of done, and that's why that additional condition was added. So if they take time to look at the condition and follow those requirements in that rule, then they don't have to operate the SIM during the period of the variance. So, and there are no excess emission during this period. So for all those, I can make the sixth finding, and I can willing to make the motion at the appropriate time for the short variance.
Thank you, Mr. Villalobos. Any other comments from any other board members? My only concern is that timeline, and it is an aggressive timeline. Especially as Mr. Villalobos pointed out, that there's one aspect of it that hasn't really been inspected yet. The exhaust, I believe, is what you mentioned. And for that reason, I'm hesitant. I'm hesitant only because my concern is that you are an essential, what we consider an essential body in this, in the respect that ultimately you do have to provide power into the grid, albeit at a peak or point and based on demand. But since we had such a horrible season last year, I'm hoping we won't have one as bad, but we may. And if you're not up and running, then you cannot provide the power or the complete amount that you're normally dedicated to providing to the grid. But that being said, if you believe that you truly can meet that timeline, I understand that you're going to do anything and everything possible. So I don't want to hold you back on doing that either. So for those reasons, I believe that I can make the 6 findings in a hopeful spirit. So with that, I don't think there's any other comments from any other board members. Mr. Balagapur?
I was going to add, once they open up and find really that they need more time, they can come back for a amendment to the variance. So that's
Correct.
always an option available to them.
Yes, and I just want to make sure that they understand that. Being that I believe this is your first time in front of this board. Granted, it's not easy for non-represented companies to come before us and know how to navigate that. But if you have questions, I strongly suggest that you give the district a call and get clarification if you're in doubt of anything. In respect to if you need to ask for another variance, if the time runs out on you. So with that, any other comments from Dr. Abraham and or Mr. Ali?
Yeah, I too can find the 6 findings and appreciate the comments that have been previously made by Mr. Balagopalan and Madam Chair.
Thank you, sir. Mr. Ali, do you have any comments?
6 findings made.
Thank you. Okay. All right. With that, I'll entertain a motion.
Okay, I'll go ahead and make the motion in the matter of Colton Power LP, case number 6164. So I'm looking at the wrong one, -3. I had the wrong 64. Let me switch here for a second. -3. I move that we grant a short variance commencing January 1, 2024, continuing through March 30th, 2024, on the following rules and subsection, which is 203B 2004, F1 3002, C1, permit condition D 28.1, and levy 134, E2C 3. And I think it's not 3, but what's it called? Anyway, Roman, yes, thank you. I forgot that. Yes. For the equipment that, for the gas turbine, net turbine number 4, identified as D22 in the facility permit 182563 for the equipment located at 559 Pepper Avenue, Colton, California, 92324. The conditions for the variance will be as set forth in the revised exhibit, well, A, with the change to condition number 2, that they will return and bring it to service before March 30th, 2024, instead of the March 31st. So that will be the only change. And of course, we noted that condition number 5, an additional sentence was added, and Ms. Pruitt clearly articulated what that condition is. So with that, and during this period, there shouldn't be any excess emission because the turbine is not operating. So with that, I conclude my motion.
Second.
Thank you. Any discussion on the motion? Okay, if not, let's go ahead and vote. Mr. Ali,
Aye.
Dr. Abraham,
Aye.
Mr. Balakopoulon,
Yes.
Mr. Pearman,
Aye.
and I also vote aye. So you have an unanimous decision there that we grant your short variance, and we wish you luck. Hopefully it'll get repaired sooner rather than later. With that, thank you very much for attending via Zoom. And to our staff, thank you very much for coming in on a holiday week. And also for all of the information you provided for this case. Thank you so much.
Very welcome. Thank you.
Thank you. If there's any other comment in regards to this case, if not, the matter is closed. Any other comments from the public in regards to any other item other than this case?
There are no hands raised, Madam Chair.
Okay, thank you very much. So with that, we are adjourned. Thank you again. Happy holidays. Happy New Year.
Thank you. Happy holidays.
Thank you.